I have some questions, and I'm sure you all do, about the new Act, but perhaps if I could commence the discussion with some questions. Firstly, to Sarah, having become enthused, having heard these three excellent talks about the new Act, where can we go, and what available resources inform an overall understanding of the Act, including the history of development of the Act? If I could invite you to use the microphone.
Hello. Yep. Well, glad you asked. There are two resources that I went to which I think are excellent. One of them is the Department of Justice discussion paper, and that's on the Department of Justice website. And the other is the Simplification of Jury Directions project, a report to the Jury Directions Advisory Group, August 2012. That's on the Supreme Court website, and that was put together by Justice Weinberg, and it really does cover all of the issues discussed by everybody today.
Thank you, Sarah. Theo, there's one thing that I don't understand, and that's probably my fault, but the expression integrated directions was given as a term of art. And
this isn't on the list. This wasn't on the list. What are you talking about? I don't know. Sorry, go on. Yes, integrated directions.
I know it's not on the list.
Yes.
What are integrated directions?
Well, is it defined? Let me have a look if it's actually... Oh, you've got an answer, have you? Oh, go for it here.
Subsection 3.
Yes. Sorry, I'm just jumping in on Theo there. I was interested in integrated directions too, so I had a look. It's a New Zealand idea, a New Zealand concept they use a lot there. It's basically combining the law with the facts in a series of questions to the jury. So rather than give them a lecture on the law and then go and summarise the facts, a series of questions, the New Zealanders call them a question trail, will be put to the jury, and it'll just be simple propositions. Are you satisfied that Bob stabbed Jane? If no, stop there. If yes, do you believe there was any legal justification for Bob stabbing Jane? If yes, stop there. If no, go on, and so on. So just a series of basic questions put to the jury to help them understand what their role is. And in fact, I think a few judges are doing this already in a if-then type of, in complex trials with lots of charges. This might already be happening. So that's basically what integrated directions are.
So does that...
Can I just add on to that? It's not defined, and all it says about integrated directions is about in the form of factual questions that address matters that the jury must consider or be satisfied of in order to reach a verdict. There are those documents being produced. I did an appeal recently with a terrorist appeal where Betty King had produced a 3-page question and answer series. So if you're satisfied of A, then B. Does it help? The document itself was still the subject of the appeal. So in some respects it did. It set out what the issues were, but the more complicated the provisions that are under question, I suppose, it only serves a limited purpose. Sorry, Ian, go on.
So does that mean in, for example, an armed robbery trial, where identification is the issue, that the trial judge would simply tell the jury that there is one issue, and that is identification, if they are satisfied, having explained to the jury about identification, if they are satisfied beyond reasonable doubt that the accused identity has been proved, he's guilty. If not so satisfied, he's not guilty.
That comes back to your obligations under Section 10. Depends what counsel's raised as an issue, and that's why it becomes very important to be clear about what you want, and you are stuck with it. If you say that's the sole issue, then that might be the question trail.
So there will be no further directions anymore about matters that are no longer in question. So you won't hear the judge say, well, these are the elements of an assault and this, etc. It will just be, this is the issue, decided on that basis.
Section 10 of the Act, and I'll just read it because it's fairly brief. Defence counsel must inform trial judge of matters in issue. After the close of all evidence and before the closing address of the prosecution, defence counsel must inform the trial judge whether the following matters are not in issue: each element of the offence charged, any defence, any alternate offence, including an element of any alternate offence, any alternate basis of complicity in the offence charged, and any alternate offence. I might ask you, Charles, what the significance of Section 10 and those words is in placing the obligation on defence counsel only.
Yeah, it is an obligation only on defence counsel at that stage, and I suppose it might be said that's right, because at that point, with the close of evidence, we should know and be able to inform the judge of those matters. I wonder, though, whether the prosecutor, though, doesn't have some obligation in there, even though the prosecutor's not mentioned, because they certainly have an obligation to ensure a fair trial for the accused, which isn't in any way removed by this Act as far as I can see, and that might be that therefore they have an obligation to engage with defence counsel in formulating those questions to ensure that that's right, because they know, this is before the closing address of the prosecutor, of course, they know what's going to be in that, and it might be helpful for defence to know that before they then make the leap of faith themselves.
Section 10 seems to place an obligation on defence counsel to tell the judge how a jury may find their client guilty.
Yes, or decide to exclude some of those considerations from the jury.
Which in part to me seems really something that should be more for the prosecutor to do than defence counsel to assist in the prosecution of the case against the client.
There's some talk that the amendments will make this obligation in the running of the trial, ongoing and on both counsels, so we'll wait and see.
Theo, what does the Act say if the trial judge wants to give a non-general direction but defence counsel oppose that direction being given, and what is the test?
So Section 15 would... we go to Section 15 and it says... this subheading is when trial judge must give direction regardless of parties' views. And depending on, I suppose, what view the trial judge takes of counsel will determine whether or not the judge activates this provision. Rare for you, I'd imagine, Ian, it never happened, but what it says is despite sections 13 and 14, the trial judge must give the jury any direction that is necessary to avoid a substantial miscarriage of justice, even though the direction relates to a matter that the defence counsel has indicated under Section 10 is not an issue, or has omitted to indicate under Section 10 is an issue, and the prosecution or defence counsel has requested that the trial judge not give the direction, or has omitted to request the trial judge under Section 11 give the direction. So essentially, trial judge makes the call. Now, before giving that direction, the trial judge must A, inform prosecution and defence counsel, or an unrepresented themselves, and B, invite submissions from prosecution and defence about the direction and whether the direction is necessary to avoid a substantial miscarriage of justice. So essentially, the judge will say, I think it's necessary to avoid a substantial miscarriage of justice, even though you've said you don't want it or you haven't raised it. I'm asking you now because I'm going to direct the jury on this issue and I want your view, and the test that we'll apply is whether or not, if I don't give it, there's going to be a substantial miscarriage of justice. And I suppose, as Charles said earlier, the trial judge's view about the strength of your arguments and your ability may very well factor into whether or not they decide to give it, because ultimately this still leaves scope for appeal provisions, because the question is whether or not it should have been given or should not have been given by the trial judge, and whether or not the trial judge should or shouldn't have decided at the time that there was a risk that there may have been a substantial miscarriage of justice. So as I said, I think it simply removes one set of grounds for appeal and replaces them with another set of grounds for appeal.
Charles, on another level, and practically speaking, how does the Act and the changes that it's made affect our interaction with our clients, our need to take instructions from our clients, and possibly our need to have our clients agree or not agree with what ultimately will be forensic decisions that we will have to make in the running of the case, for which the Act seems to put more of an onus on us now?
Yeah, and I think this is kind of critical, and that's why I say the Act affects the solicitors as much as the bar, because this will inevitably involve drawing the client into discussions about which directions you want or don't want given, and it may, for instance, removing from the jury an alternate verdict to avoid any compromise verdict, for instance. It may be a fairly big call, and you might very well want now to sign your client up on that, because you are, by making the call, as you're required to do under the Act, you're required to consider it and make it under consideration. If it backfires, could be implications. So I think that's something that barristers, solicitor and the client will have to be involved in together at that stage.
There could be some interesting discussions with some of our clients regarding those matters. Are there any questions from the audience regarding the Act and its changes?
It sounds like the jury's going to be kept in the dark for a while these discussions are happening, because everyone's going to be finding it hard to comprehend what to do in the early stages, and the jury will be locked out for lengthy periods of time until everyone gets the hang of it, I suppose.
I think it's a good question, and probably more by way of statement, which I'm about to repeat. Thank you, Mark. As I understand it, it is simply this: from a practical point of view, there are going to be a lot of discussions over lengthy periods of time between counsel and the judge regarding these matters, during which time the jury will be excluded from the courtroom and kept in the jury room, or either sent home for possibly days on end. But I think necessarily that's going to be the case. For those of you who have been involved in sex offence trials, particularly of recent times, we've been having these discussions informally with judges now for some time. And as you would appreciate, under the Crimes Act and under the Criminal Procedure Act, there is an obligation on defence counsel to seek, well, there had been, certain directions in sex trials, like a forensic disadvantage direction. So we've had a bit of a trial run at some of these things, but I think you're right. I think juries will be sent out whilst we debate these things, perhaps not endlessly, but there will be much more interaction between counsel and the judge in the shaping of the trial and the directions. Yes?
I've just got the Act's only been in place now for about 5 or 6 weeks. I'm just wondering anecdotally whether any of the panel members or anyone else in the room has been able to share any experiences that they've either been involved in or heard about in relation to the extent to which judges and counsel are actually following the spirit of the Act, or whether old habits die hard.
I don't think any trials are finished yet. I don't know of any.
I've heard one interesting anecdote that a judge who I won't name in a trial recently just refused to follow the new directions on summarising the evidence and went ahead and summarised closings and evidence in the old way. So there you go.
I'm in a sex trial at the moment, and there was the incidence of the jury being sent out for an afternoon whilst the discussion took place about what directions would or wouldn't be given. The act was followed. The charge was really short in comparison to what it could have been, and the summaries were very brief. So it seems to be progressing.
Any further questions?
I think I missed earlier. Was it put there will be a mandatory direction where there's a notice of incriminating conduct given, a consciousness of guilt type direction in all cases where such a notice is served? Or is that one of the ones that we have to request?
We'll find the section, but my understanding is it's mandatory.
And as a follow-up, I haven't checked, but is there a list in the Act of the general directions that will still be given? Presumably the burden of proof and standard of proof and the like will always be given, the role of parties, I think you said. Is that included in the Act?
There's a list of the general direction topics.
In the definitions are listed the general directions. So general directions means directions concerning A to I, setting out the basic stuff that he or she will give as directions anyway.
And just because I'm lazy so I don't have to look it up myself later, is the consciousness of guilt direction in there? Yes. It is? Okay, thanks.
And can I say something on that? That's raised an important point. There's a mandatory direction under Section 25 if the notice is given, but there's also an obligation under Section 26. If the trial judge gives or proposes to give the direction under 25, Defence Counsel may request under Section 11 that the trial judge also direct the jury that, and then these are the directions that come out of the old common law obligations, that there are all sorts of reasons why a person might behave in a way that makes a person look guilty, etc. And that's another forensic decision that Defence Counsel will have to make. Do you want to highlight the lies, or do you want to just let them go through to the keeper, essentially? And that's a decision that, again, that's a big change for Defence Counsel in the running of a trial. That decision will have to be made.
Can I really suggest that we all either photocopy or purchase the Act? It is short, as has been said, but it does represent a significant change. We can call it a cultural change if you like, but it is a significant change to the way in which we will operate in trials, and there is more of an onus put upon us, particularly as Defence Counsel, and most of us don't relish being criticised by the Court of Appeal for not having done things correctly and to the benefit of our clients. So can I ask that you all get the Act and read it and study it. And it's going to be a developing area. This is just the first step in what are going to be further simplified directions. Yes, your lucky last question.
Thank you. Because this is the first in a number of acts to come through, is anyone concerned that it undermines the uniformity of the Uniform Evidence Act to introduce these changes in this manner?
I was reading on the Judicial College site about, I think it was directions about intent, and it was talking about what they've done is they've actually integrated the requirements under the Common Law with some Evidence Act requirements and or Criminal Procedure Act and the Juries Act. So I can't remember the example, but I remember thinking last night, to the extent that there's now a number of sources about that inform what a judge needs to say, it's actually necessary for regard to be had to each of those sources in order to reconcile what a proper direction should be. So I don't know if undermining is necessarily correct. It's certainly a certain amount of overlay, but I think that charge book that's online is such a wonderful resource in terms of we're moving towards a PowerPoint society anyway, and in some respects I don't think that this change is really that dramatic because it's probably how juries now think, and I don't think that juries that you sit there and explain things to without the aid of some aide-memoire anymore have the capability of listening and comprehending and retaining information. And so probably without some written jury guides that they're talking about under the Criminal Procedure Act and some formalised jury questions, I actually don't think they're capable of answering their function at all anymore. So probably not compromise, but certainly there's a whole generalised push, I think, and the website sets out that there is a range, but once they're integrated together, it does actually make sense.
I think we've run out of time. Sadly, you can perhaps ask or make observations later. Sadly, some of us have other places that we have to go to. But I wonder if you could join with me in thanking the presenters because I think we are all much better informed now about the new Act. And I thank each of you. And in turn, can I thank you for coming along? If we don't have people coming to these breakfasts, we won't hold them. And this, I think, has been informative. At least I've learnt some things that I didn't know about the Act, which no doubt will be practical or of practical application in forthcoming trials. So thank you very much, and good luck in your application of the principles of the Act. Thank you.